Welcome back to Juvenile Justice Policy, CRJU 303A. Today we'll be discussing juvenile justice procedures. After today's lecture, you should be able to identify juveniles' rights from custody through appeal, explain police procedures for taking youth into custody and bail requirements, describe juvenile court procedures including hearings, petitions, and notifications, and be able to outline procedures for detaining juveniles. Since the In re Galt decision in 1967, juveniles alleged to be delinquent have been guaranteed several basic rights. They must receive notice of the charges against them and sufficient time to prepare a defense, have the right to legal counsel, the right to confront and cross-examine witnesses, and the right to remain silent. The protections of the Fifth, Sixth, and 14th Amendments apply to juvenile proceedings, and courts generally evaluate a juvenile's competency to waive rights under Miranda based on factors such as age, understanding, and education. The Uniform Juvenile Court Act further ensures that juveniles are represented by counsel in delinquency, abuse, neglect, and dependency cases. If no parent or guardian is available, or if their interests conflict with those of the juvenile, the court may appoint a guardian ad litem. Juveniles are also protected under the Fourth Amendment, so evidence obtained illegally is inadmissible, and confessions alone cannot support a delinquency adjudication without corroborating evidence. Additionally, juveniles have the right to present evidence, be heard, and cross-examine adverse witnesses. The standard of proof varies depending on the type of case, with delinquency cases requiring proof beyond a reasonable doubt, while dependency cases often use a clear and convincing evidence standard. Some rights guaranteed to adults are not extended to juveniles. For example, juveniles generally do not have a right to a jury trial or a public trial, although some states allow jury trials by statute or judicial decision. The juvenile justice system is designed to be largely non-adversarial, focusing on rehabilitation while also protecting the public. Bail for juveniles, or release from custody pending trial after payment of a court-ordered sum, is a controversial issue. Some jurisdictions allow bail, while others do not, reasoning that juveniles have not been formally charged with a crime and therefore are not entitled to it. Many states provide special release provisions, returning juveniles to the custody of parents or guardians, which has made bail less of a pressing legal concern. For example, Hawaii prohibits juvenile bail. Several states allow it at a judge's discretion, and others grant juveniles the same bail rights as adults. Juvenile records are generally maintained separately and kept confidential, accessible only by court order or according to strict state guidelines. Arkansas, for example, keeps adoption records closed, allows prosecutors access to certain delinquency adjudication records for sentencing or adult trial purposes, and retains records of serious offenses for 10 years. Under the Uniform Juvenile Court Act, a child may be taken into custody by court order, under arrest laws, or by law enforcement if there are reasonable grounds to believe the child is in danger, ill, injured, or has run away. Generally, juveniles can be detained without a warrant if suspected of delinquency, needing supervision, or being abused or neglected. Some states, however, limit this power to prevent unnecessary removal from homes, reserving it for situations of imminent danger. For instance, Illinois allows officers to take a juvenile into temporary custody when there is reasonable cause to believe the child is delinquent, dependent, abused, or neglected, or if a court-committed juvenile escapes. Similarly, Alabama permits officers to take into custody any juvenile who has run away from a care facility or is found in public needing medical care. Temporary custody under the Act is not considered an official arrest, although juveniles may still be held involuntarily. When detention is based on delinquency, law enforcement must follow constitutional safeguards, whereas for other protective reasons, parens patriae principles justify the custody if not abused. During interrogation, juveniles have rights similar to adults. Courts evaluate the voluntariness of statements based on the totality of the circumstances, including age, understanding, and the nature of the questioning. Juveniles should receive Miranda warnings, and many jurisdictions require the presence of a parent, guardian, or custodian during questioning. For example, In Colorado, statements obtained without these safeguards may be considered inadmissible. Juveniles taken into custody may either be detained or released to a parent or guardian. Model Acts and the Uniform Juvenile Court Act require police to make an immediate and reasonable attempt to notify the juvenile's parents or guardian, typically including phone calls or visits to home or work. In Oregon, officers must inform the parent or guardian of the action taken and the time and place of the hearing. Juvenile court hearings consist of the following: a detention hearing, a preliminary conference, the petition, the notification, adjudicatory hearings, predisposition investigations, and dispositional hearings. When a juvenile is brought to a detention center, an intake officer decides whether to release the child or hold them for further proceedings. If the juvenile is not released to their parents immediately, most states require a detention hearing within a specified period. Reasonable notice must be given to the juvenile and their parents or guardian, and the court must inform them of the right to counsel and the right to remain silent. Section 17 of the Uniform Juvenile Court Act directs intake officers to investigate the circumstances and release the juvenile unless further detention is warranted. If the juvenile is not released within 72 hours, an informal detention hearing is held to determine whether continued detention is necessary, usually focusing on the protection of the juvenile, society, and the prevention of flight. For example, Illinois law requires intake personnel to release a minor to their parents unless detention is immediately necessary to protect the minor, others, or property, or to prevent flight. Detention may be authorized by the intake officer for up to 36 hours, after which the juvenile must be released or brought before the court. Failure to file a petition or schedule a hearing within 40 hours requires release. Other states set 24, 48, or 72-hour standards, typically excluding weekends and holidays. West Virginia law provides that the sole mandatory issue at a detention hearing is whether the juvenile should remain in detention, and the court should release the juvenile on recognizance unless detention is warranted for safety, with bail considered where appropriate. Many juvenile cases are resolved informally at the intake stage. Intake personnel, the juvenile, the family, and any injured parties may adjust disputes without formal court proceedings. Some states explicitly encourage this, as in Tennessee, where probation officers may offer counsel or advice for informal adjustment if it is in the best interest of the public and the child and the parties' consent. Only the most serious cases, serious delinquency, unruly behavior, or abuse and neglect, move through the full juvenile justice process. While participation in informal adjustments is officially voluntary, juveniles or their parents may sometimes perceive pressure to comply, raising legal and ethical concerns about the presumption of innocence. Under the Uniform Juvenile Court Act, a child taken into custody should not be detained or placed in shelter care before a hearing on the petition unless detention is necessary to protect the child or others, prevent flight, or because no parent or guardian is able to supervise the child. If none of these conditions exist, the child must be released to their parents or guardian, who must promise to bring the child before the court. Failure to do so results in a warrant for custody. The Act directs the children be released to their parents or guardian as quickly as possible unless detention is warranted, reducing the need for unnecessary confinement in intimidating facilities such as jails or police lockups. If detention is required, the juvenile must be taken promptly to the court or a court-designated facility. Local jails may only be used if no detention home or center is available, and juveniles must be housed separately from adults in sight and sound. Hawaii, for example, certifies facilities to ensure compliance with sight and sound separation standards. For juveniles not accused of delinquency, shelter care facilities, physically unrestricted, state licensed, and designated by the court, are typically used. These include children who are abused, neglected, or status offenders. The procedures for contacting parents or guardians and determining custody and shelter care follow the same criteria as for delinquent children. Maximum detention periods are set by state juvenile court acts and prevent prolonged confinement without court review. After custody is established, officers of the court may attempt to resolve the case informally through preliminary conferences before proceeding to a full court hearing. The Uniform Juvenile Court Act allows a probation officer or other court-designated officer to hold a preliminary conference to provide counsel or advice and potentially resolve the case through an informal adjustment without filing a petition. This conference may occur only if the facts fall within the court's jurisdiction and if an informal adjustment, without formal adjudication, is in the best interest of both the child and the public. The juvenile's parents or guardian must consent to the conference, which is not mandatory. If all parties reach an agreement during the conference, no further official action may be needed. If judicial action is required, the probation officer may recommend filing a petition, but any request by the injured party to file a petition must be honored. Preliminary conferences aim to divert cases that can be resolved outside the formal court process. However, they have been criticized for potential coercion without trial. Generally, information or evidence presented at a preliminary conference is not admissible in later juvenile court proceedings. Official juvenile court proceedings begin with the filing of a petition, which names the juvenile and alleges that the juvenile is delinquent, dependent, abused, neglected, or in need of supervision or intervention. While states vary on who may file a petition, they generally agree on the content and follow-up procedures. Some states conduct a preliminary inquiry before filing to determine whether a petition is in the best interest of the child or public, while others do so after filing, potentially resulting in dismissal if the allegations are unsupported. Regardless, the court must endorse the petition as being in the best interest of the child and the public. The Uniform Juvenile Court Act specifies that anyone with knowledge of the alleged facts may file a petition, but the court or its designee must approve it before filing. In some states, signing the petition and filing it are separate acts, requiring court personnel to verify the sufficiency of allegations. The petition itself is generally filed in the interest of the child and includes the juvenile's name, age, and parents' names and addresses, along with the child's detention status. It also outlines the facts that bring the child under the court's jurisdiction, and if delinquency or unruly conduct is alleged, must include information about the child's need for treatment or rehabilitation. Once completed, the petition is filed with the prosecutor, who decides whether to pursue the case. If prosecution proceeds, all concerned parties are properly notified. Notification ensures that all interested parties are officially informed of the time, place, and any changes to juvenile court proceedings. The U.S. Supreme Court in Galt established two key requirements for notification. It must be timely and adequate. While petitions do not need to meet all the formal requirements of an indictment, they must describe the alleged misconduct with enough detail for all parties to understand the charges and for the juvenile to prepare a defense. Once a petition is filed, the court issues a summons to all relevant adult parties, notifying them of the adjudicatory hearing and their right to counsel. Many states also require a separate summons for the juvenile if they are above a certain age or fall within a specific category, such as delinquent or unruly. The petition typically accompanies the summons unless the summons is served by publication in a newspaper. States vary in how much time must pass between service of the summons and the hearing, but in accordance with Galt, parties must have a reasonable opportunity to prepare. For example, Illinois requires at least 3 days if served personally, 5 days if served via certified mail, and 10 days if served by publication. Texas law provides similar requirements, allowing at least 2 days for personal service within the state and 5 days for certified mail or for parties outside the state whose location can be reasonably determined. Summons may be served by any court-authorized person, usually a sheriff, coroner, or juvenile probation officer. If the court receives information indicating that the juvenile must be placed in detention or shelter care, the summons may include an order for immediate custody at the designated facility. Following proper notification, the adjudicatory hearing is held, which, in delinquency cases, functions as the juvenile court's equivalent of a criminal trial for adults. The adjudicatory hearing is a fact-finding process to determine whether the allegations in the petition are valid. In delinquency cases, it is roughly equivalent to a criminal trial, while in cases of dependency, neglect, or intervention, it more closely resembles a civil trial. The U.S. Supreme Court has extended due process to juvenile proceedings, but not all constitutional rights apply. For example, juveniles do not have a constitutional right to a jury trial. Most cases are heard by a juvenile judge, and the Uniform Juvenile Court Act recommends hearings without a jury. The standard of proof varies by case type. For delinquency or unruly conduct, the state must prove the allegations beyond a reasonable doubt. For cases involving deprivation, abuse, neglect, or dependency, a preponderance of the evidence or clear and convincing standard is typically used. The Act also allows the use of clear and convincing evidence to determine the child's needs for treatment or rehabilitation. Hearings are generally closed to the public to protect the child, though some states allow open hearings in certain criminal cases. Judges may close hearings if it is in the best interest of the child, admitting only parties, counsel, witnesses, and those with a legitimate interest, such as members of the press under confidentiality requirements. The principle of a speedy trial applies to juveniles, with statutes often specifying time limits between detention, adjudicatory hearings, and disposition hearings. However, delays sometimes occur, and motions to dismiss for procedural violations are infrequently granted. After hearing the evidence, the court makes findings on whether the child is deprived, delinquent, abused, neglected, or unruly. If the allegations are unsupported, the petition is dismissed, and the child is released from any restrictions. If the allegations are supported, the court may immediately determine treatment or rehabilitation needs, or hold a separate hearing for that purpose. Even if the child meets the petition criteria, the court may decide that treatment or rehabilitation is unnecessary and dismiss the petition. Juvenile judges may also continue the case under supervision, postponing adjudication while observing the child. If no further issues arise, the petition is dismissed. If problems occur, the court proceeds with the original hearing. This procedure allows juveniles to avoid formal adjudication, but may involve court oversight that could be perceived as coercive if the child did not commit the alleged act. A ward of the court is a child for whom the court exercises parental authority, in loco parentis. Decisions normally made by parents are instead made by the court or probation officers. Determinations regarding custody, treatment, or rehabilitation may occur during the adjudicatory hearing or a separate dispositional hearing with the standard of clear and convincing evidence recommended for wardship. Priority is given to children in detention or removed from their homes. Some jurisdictions also place children under probation or supervision without formal findings, to divert less serious cases from adjudication. While this can prevent stigmatization, it has faced criticism for potential violations of due process. Once the adjudicatory hearing determines that the allegations in the petition are valid and that wardship is necessary, a dispositional hearing is scheduled to decide the final outcome of the case. In some states, adjudicatory and dispositional hearings are separate due to differing procedures and standards of proof. For instance, in delinquency cases, criminal standards of proof and evidence apply at the adjudicatory hearing, while civil standards are used for dependency, neglect, abuse, or supervision cases. However, at the dispositional hearing, all evidence helpful in determining the child's needs, oral, written, or otherwise, may be considered, even if it was not admissible at the adjudicatory stage. Between the adjudicatory and dispositional hearings, court staff, usually probation officers, conduct social background investigations, also called social summary reports or predisposition investigations in some states. These reports are designed to provide individualized justice and help the judge make an informed dispositional decision. Typically, these investigations gather information on the juvenile's personal history, family and parental background, school performance and attendance, employment or work history, if any, peer and social relationships, and environmental factors. Information is collected through interviews with the child, family members, school personnel, and other relevant community members. The findings are compiled in a report for the judge to review. Some courts also allow staff to make recommendations regarding the appropriate disposition or to suggest the elimination of certain options. However, the probative value of some information can be questionable, and it may be challenged during the dispositional hearing. Improper use of social background investigations prior to adjudication has historically risked adjudicating delinquency without proving the alleged acts a concern addressed in Kent v. United States. Following this decision, juvenile counsel has the right to review social background reports used in waiver hearings. Most juvenile court acts extend this right to counsel representing the child during dispositional hearings, ensuring that staff reports are not treated as automatically accurate or binding. While the adjudicatory hearing determines whether the allegations in the petition are supported by evidence, the dispositional hearing focuses on what interventions or alternatives best meet the needs of the juvenile. In many states, the rules of evidence do not apply during dispositional proceedings. Dispositional options vary depending on the juvenile's category: deprived, delinquent, unruly, or in need of supervision. And each state's Juvenile Court Act specifies which alternatives are available. For a deprived child, the Uniform Juvenile Court Act, Section 30, allows the child to remain with his or her parents, subject to conditions imposed by the court, including supervision. Alternatively, the child may be temporarily transferred to a qualified individual approved by the court, to a licensed agency or private organization authorized to provide care, to the Child Welfare Department or another public agency, or to an individual in another state with or without supervision. For a delinquent child, the Uniform Juvenile Court Act, Section 31, allows the court to apply any disposition authorized for a deprived child. In addition, the court may place the child on probation under the supervision of a probation officer, subject to conditions prescribed by the court. The court may also commit the child to an institution, camp, or other facility for delinquent children, or commit the child to the State Department or institution designated for delinquent youth. For an unruly child, the court may impose any disposition available to delinquent children, except commitment to a state correctional agency. If the unruly child is found not amenable to treatment under the current disposition, the court may hold another hearing and make any disposition otherwise authorized for delinquent children. A general trend in juvenile court acts is to refrain from committing children in categories other than delinquency to correctional institutions unless other alternatives have failed. Juveniles demonstrating mental challenges or mental illness may be transferred to the appropriate authority within the state. Many dispositions now include conditions for attendance at community-based treatment programs or child guidance centers, particularly for probation or suspended sentences. Violations of these conditions may result in a revocation hearing. Most states specify maximum periods of confinement, and any extension of the original disposition generally requires another hearing, with all rights afforded in the original disposition hearing. The court may, under certain circumstances, terminate a dispositional order early if the purpose of the order has been accomplished. Juvenile courts acts generally terminate all orders affecting the juvenile when he or she reaches the age of majority, releasing the youth from further obligations or court control. When probation is the disposition, both the conditions of probation and its duration are explicitly specified by the court. In conclusion, juvenile justice practitioners must know proper procedures to protect juveniles' rights and serve society. Errors in custody, interrogation, or notification can block prosecution and prevent rehabilitation. Each state's Juvenile Court Act guides actions from apprehension to disposition, and practitioners must follow it carefully. I'll see you in Chapter 9.